We have one case scheduled for oral argument this morning, the case of Rooms to Go Warehouse versus Harry King. You may approach counsel. Again, counsel, we have allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
2 minutes, Judge.
So noted, Madam Clerk. You may continue, counsel.
Thank you, Judge. May it please the court. In this case, the JCC awarded compensability of medical terms contained in what the doctors called a poor quality MRI report. But medical terms contained in an MRI are not injuries, they're not conditions, they're not diagnoses. MRIs are tools, and physicians use them to diagnose injuries and conditions. Spondylosis, stenosis, and other terms that are found in MRI reports are descriptors of radiographic findings. And without clinical correlation, they are meaningless. Dr. Cronin testified that carriers have to look at the office notes for information since laymen are incapable of interpreting MRI findings. Both Dr. Cronin and Dr. Weber testified that none of the MRI findings related to the work injury, and in fact, the claimant does not even have the herniated disc that the judge found compensable. There were 8 walk-in clinic visits, there were 2 orthopedic visits. Every office note that the carrier received contained the diagnosis of cervicalgia, of strain, or of contusion.
Counsel, before you go too far into the merits of the case, would you address the jurisdiction of this court to hear this appeal?
So I presume, based on that question, are you talking about the fact that the judge did not actually award treatment?
He didn't award anything, correct?
Yeah,
there was no claim for benefits that was awarded by the JCC.
Right, he found that the injuries or the findings in the MRI were compensable, but at the beginning of the trial, claimant's trial counsel withdrew the claims for treatment. There was a claim pending, it's in the pretrial stipulation, for an orthopedic and for therapy, and at the beginning of the trial, for reasons I do not know, he decided to withdraw those and says, I'm only seeking compensability.
Right, but you don't award compensability. It's a determination that the JCC makes. And so what I'm getting at is Florida Rule of Appellate Procedure 9.10, 180 B1C, which requires that the JCC make a certification when there is an appeal dealing solely with compensability.
Well, Your Honor, I'll happily take a reversal for lack of jurisdiction and a remand for the case, for the judge to actually decide the benefits that may be awardable based on his conclusion that that these MRI findings are compensable. And
could I just stop you? I just want to make and just clarify a point. We couldn't even construe this as a final order because there's no claim for benefits that's being addressed, whether ripe or not ripe, in this particular order, correct?
Well, I'm not sure that's correct, Judge, because the claims, if you look at the claims, as both pled in the petition and in the pretrial stipulation, there were itemized claims. One was compensability of MRI findings. That's a claim. And in fact, the judge, if you look at the decretal portion of the order, the judge awarded compensability and then just verbatim quoted everything from the MRI. So claim 1 was compensability of MRI findings. Claim 2 was, I may be getting the numbers wrong, but another claim was I want an orthopedist to treat these conditions. And the third was I want therapy that's been recommended, I think, by the IME doctor, Dr. Smith.
I think I'm concerned, though, with the term award here. I mean, when we're talking about a petition for benefits, right, compensability is not a benefit within the meaning of Chapter 440. Isn't that correct?
I would agree with you, Judge, because what good has it done this particular injured worker to go to a trial and have the judge say these MRI findings are compensable and the claimant leaves that hearing getting nothing at all? So I think that your jurisdictional argument is well taken. And had the judge said, I'm going to find that these MRI findings are compensable, and since they're compensable, carrier, you must provide treatment for those MRI findings. And that's what the judge didn't do, and that is because the claimant, through his lawyer, of course, withdrew the claims for treatment at the time at the commencement of the trial.
And of course, the claimant was entitled to do that, right? They could take a voluntary dismissal without prejudice.
Yes,
correct?
they're entitled to do that at any time prior to the close of the evidence. So he could have done that, after they rested their case and before we finished ours. He could have said, Judge, I'm hitting pause, I take a voluntary dismissal, and there's nothing the judge can do because a dismissal of the petition, per your cases, deprives the JCC of jurisdiction to do anything at all. So I guess your fundamental question is, if the judge says, I award compensability, but I don't order the carrier to provide anything, is it a non-final order? And if it's a non-final order, to make it appealable, I would need the 9.180 certification where the judge says, I certify that the claimant has suffered a compensable injury, but the exact nature of the benefits due would require substantial time and expense.
Right, and on this record, the JCC would be unable to do that because the determination of the benefits that were originally sought would not have taken substantial time and because it was PT and I don't recall the other claim.
It was therapy and an orthopedist.
Right.
And it could not have been more ripe, I think, because you had a fully fleshed out record where the orthopedic physician, the authorized orthopedic physician testified, and then the two IME doctors both testified, and the fundamental dispute or disagreement between the doctors was whether these radiographic findings meant anything at all, and whether what was wrong with him at that time related back to the 2022 work accident. So I will concede your point that I think there is a lack of jurisdiction. And if there's a lack of jurisdiction, then the court, I guess, cannot even consider the merits of the arguments, correct?
That would seem to be the case, although it's certainly an interesting question.
Well,
While we have you here,
what's that?
I say, while we have you here, why don't we ask a little bit? Because
Sure.
We've got two excellent appellant practitioners who know comp very well, and this is an issue that appears to be coming up with some frequency in our cases. It seems like if compensability or compensable in 440.13.1D means the same thing as compensability in 440.20, then we maybe have some inconsistency in our recent case law.
Okay, Judge, this is really the fundamental premise of my brief is exactly that question, okay? So I'm old. I've been doing this nonstop for 35 years. And I was a young lawyer when this law originally passed, 2004, January 1, 2004. And the court, frankly, whiffed on the first 3 or 4 cases that came out. And then I got a case, cited in the brief, North River Insurance Company versus Welling. And we were ordered to do supplemental briefing. I was making the same argument I made in the brief here, okay? We were ordered to do supplemental briefing on how 440.20 works. We did that, and then I came up here and I did an oral argument in front of the whole court. Smaller court then, but all the judges were, and it was the old courthouse, but you're all crammed in up there, and we do the oral argument, and the court says, okay, we whiffed. We're receding from those earlier cases, and here is what 440.20 means. They said, the waiver provision, subpart 1 and 2 require the carrier to deny compensability or pay benefits within 14 days after what? The receipt of the notice of injury. And if the carrier can't figure it out in 14 days, what 440.20 subpart 4 does, according to the court, was allow the carrier to postpone the decision to deny any obligation to pay benefits for up to 120 days while you conduct your investigation. So both are triggered by the receipt of the notice of injury, and you had it exactly right. And then there were some other bad cases, and then Checkers v. Whiteoff, another en banc case, 10 years later, 2006. The court said this, and I agree with this statement. The waiver provision of 440.20 subpart 4 pertains solely to the concept of compensability. In failing to deny compensability, here's the key language, the EC only admits that there was an industrial accident resulting in some injury to the worker. Okay? Take this case. We did not deny compensability within 120 days. So what did we concede? We conceded that the claimant suffered a neck injury and a shoulder injury. The claimant suffered a compensable neck injury and a shoulder injury. We can't go back now and change our mind and go, Well, he didn't report it within 30 days. We're denying compensability. Something that would allow us to deny that the accident was ever compensable in the first place.
But then on Speedy's v. Yellow Transport, which you were also on,
Yep.
the court said once compensability of an injury is established, a carrier could no longer contest that the accident is the MCC of the injury.
Yes, I agree.
Is that a correct statement?
And let me give you the context of that. So what happened in Checkers was that the EC expressly accepted an L5S1 disc herniation and treated it for 5 years, including surgery. And then later tried to say that for that disc, the one we expressly accepted, the work accident was no longer the major contributing cause. And you said you can't do that. Here's the distinction in this case, Judge. We never provided treatment at all for these MRI findings. The only treatment that was provided was 2 visits with an orthopedist and therapy. And what did the orthopedist say in his deposition? He said, I did not order that treatment for these MRI findings. I ordered the treatment for a neck sprain. So what we provided treatment for was what he suffered, a strain to his neck. And these underlying MRI findings, we never treated. Nobody asked us to. The adjuster said, when I got first asked to provide treatment, to authorize treatment for these MRI findings? The petition. That was the first time I get a petition that says, please treat the MRI findings. She denied it immediately.
Well, one wrinkle we have, I think, in this case, and I think you would concede, and it's in the JCC's order in paragraph 26, is Dr. Cronin's treatment with PT and his filling out of the DWC 25 form, where he said if he hadn't filled it out in the way he did, the claimant wouldn't have gotten the PT. What do we do with that?
Okay, well, that is Dr. Cronin's, I think, incorrect assumption that he thinks that he must write in something objective in order to get the PT authorized. That's his perception, but that's not true. And what's important is, so the judge found that word, spondylosis, very damning, because the spondylosis was contained in the DWC 25. Now, let's look at it in context, because the actual office note, where Dr. Cronin says, if you want my opinion, go there, it simply says the only diagnosis is cervicalgia, which is neck pain, okay? But here's what he says about that spondylosis that he wrote in the DWC 25. Page 311 of the record, his testimony, I quote, the spondylosis had nothing to do with my referral to physical therapy. So it's as if you find on an MRI a tumor, or you find on an MRI some incidental finding. It doesn't mean that's what we're treating.
I can understand that argument, but what is the adjuster supposed to do when they get this form? It lists his condition, it authorizes physical therapy as treatment. Can't it be read the other way as well? Would you concede that much?
I would, if the doctor hadn't explained what he meant. Because the doctor could mean that I'm saying I want this spondylosis treated. That could be a reasonable interpretation. Or it could mean, in the office note where it says cervicalgia, I'm doing physical therapy for the cervicalgia. It could mean that too. But if the doctor's asked, well, what did you mean? And he goes, I didn't mean the spondylosis. I meant for the strain. That's what I meant it for. I think that sort of undermines any conclusion that it would be reasonable for the judge to conclude otherwise. I see I'm in my rebuttal time.
You are, counsel.
Thanks, Judge.
Thank you, counsel.
Good morning, Your Honors. May it please the Court. Michael Weiner here on behalf of Mr. King. I suppose I'll begin with your question, Judge Rowe. That was my sixth point as to the reason why it would be appropriate for this Court to affirm the decision of the JCC. I think the jurisdictional problem is a clear and present one. This was the appellant's responsibility to have secured a certification from the judge of compensation claims under the rule that the exact nature of the termination of benefits would require substantial time and expense. They didn't do that. The proper remedy here is not to reverse the JCC. The proper remedy is to dismiss their appeal for lack of jurisdiction, which makes the claimant the prevailing party. The carrier is asking you to do something different. They're asking for a reversal, which in effect would make them the prevailing party. There's a critical distinction here. We think a dismissal is appropriate of the appeal because, as we've alluded to all along in our brief, there were no benefits awarded. So we see this happen all the time, right? We have a compensability determination that could be predicated on a rising out of, or statute of limitations, or going and coming. And your question raises all these points. At that point, if the judge makes a determination, he's rendered, in essence, what is a non-final order.
Right, and so, and you would concede that compensability is not a benefit under Chapter 440.
This is
So
what-
you don't award compensability, you determine it.
Correct. This is what we've argued all along in our briefs, that there's
Counsel,
no harm, no foul
Is it
here,
your
right?
position that we do not have a final appealable order before us?
Yeah, without the certification that the appellants were bound and obligated to secure from the judge, right? And it happens all the time in workers' compensation. You file a motion. Sometimes what this court will do is this court will issue a notice that this does not appear in a show cause order. And then we'll go back to the judge of compensation claims. We'll file a motion for the certification. The judge will issue an amended order. In that amended order, he'll put in the language in there about how determination of the exact nature of benefits requires substantial time and effort.
But in
And
that-
voila, we have a
in
final
this
order
case,
that's
should we
appealable.
dismiss the appeal for lack of jurisdiction, or should we remand it to the JCC to enter a final appealable order?
Well, I think at this point you dismiss for lack of jurisdiction. They had their chance to choose the appropriate remedy. They failed to do that. We're already way across the finish line here.
Right, and would you concede that the certification would likely not have been available here on the facts of this case? I mean, the certification requires, that it would take substantial time and effort, hard to determine the benefits. The benefits here were very easy to determine.
Respectfully, what I would tell you is that's the judge of compensation claims determination, not yours,
Sure.
okay? And it's not this court's responsibility to make that determination as a matter of first impression. This is why we have judges. The judge would have had the responsibility to make whatever fact findings were necessary, and this is a reviewing court who would then review that determination either for competent substantial evidence or for on a de novo review. But it's respectfully not this court's responsibility or duty to say, well, we think it wouldn't have applied anyway.
Well, I think what I'm getting at is the question that Judge Lewis asked about remand. Is remand an available path versus dismissal? And, a remand would not be warranted if it were futile. So if assuming that the panel didn't agree that the only path is dismissal, would remand be available if it appears on the face of the record that that certification could be
I
made?
don't even think you need to remand because they're wrong on their arguments, right? If maybe they had presented arguments, and I can get to the merits of it, and I would love to answer Judge Bilbrey's question as well. But the fact of the matter is they are wrong on the facts and they are wrong on the law. There's no need to remand here. They're wrong on the facts because the judge did not make his compensability determinations based on an MRI. He clearly said Concentra saw him on March the 8th, and they diagnosed him with herniated discs, right, that were work-related. That is in the record at page 424. Then Dr. Cronin saw him on March the 23rd. And on March the 23rd, Dr. Cronin said, completes the DWC 25, and he says, herniated discs, work-related, right? Now, he may have backtracked that later on, but the judge reconciled the inconsistency within his own testimony, and in the motion for rehearing, especially the judge, found that the actual report from that date was the one that should be followed. And most importantly, they got a massive tipsy coachman problem that they don't even answer in their reply brief, right? The judge found that the claimant's IME, Dr. Smith, testified that the work injury was the major contributing cause of all of this. So I kind of posit the question based on that, why are we even here, right? The problem they have is not only a jurisdictional problem, but the tipsy coachman is really a nuclear problem for the
Let me
carrier.
take you back a step from that. Why were you even in front of the JCC if the only determination is compensability, but there's not a subsequent determination to be made of what benefits flow from that determination of compensability?
Well, and I'll answer that question the same way I did before. We see these compensability determinations occur all the time. It could be just on bifurcated proceedings to determine arising out of. That's what, on compensability determinations determine a statute of limitations, where you're not adjudicating a certain benefit, you're just adjudicating what potential entitlement might exist. And judges do that all the time. And as a result of that, they render non-final orders. Those non-final orders, for you to conduct appellate review, have to be fortified by the appropriate certification, which the appellants failed to secure here.
Counsel, were the withdrawn claims ripe for determination by the JCC?
Were the which claims, Your Honor?
Withdrawn claims.
No, absolutely not, Your Honor. Once the claimant withdrew those claims, the judge of compensation claims had no jurisdiction whatsoever to adjudicate them. And I suppose maybe the carrier could have objected and said, hey, there's nothing at issue here except compensability determination. They didn't do that. They went along willingly and never raised that argument at all, not even at the appellate stage of the proceedings.
Well, I mean, it seems that 9.180 does provide a path where there is some uncertainty about determination of benefits for the parties to get an early resolution on that issue. And the legislature has said the Supreme Court can adopt rules. The Supreme Court did and said you can, appeal this non-final order when the certification is present. So I think I wouldn't quarrel with, an EC or a claimant trying to get that issue before a JCC determined in the appropriate case.
Yes, and I agree, Judge. I think we see it all the time, right? And it does foster, because sometimes it's more appropriate, and this is what I think why the rule exists. Sometimes it's more appropriate for the parties just to resolve one thing rather than everything, right? Because that's why we have the language in the rule about substantial time and expense to resolve all these other things.
When turning to the substance of this, if we somehow have jurisdiction to adjudicate this on the merits, in Churchill, which I'm sure you're familiar with, we had that 2 years ago or so, we determined that it was compensable under 440.24, but we said other issues concerning the worker's entitlement to benefits remain subject to challenge, including the extent of the compensable injury and the causal relationship between the compensable injury and the condition for which the worker seeks benefits, and that was citing the Checkers case that Mr. Rogner pointed to. If that applies here, if we've got jurisdiction to apply that here, how would we apply that given that the JCC has already determined that these specific conditions are compensable? Did he go too far in saying, this specific T1 injury is compensable?
Okay, and I'm glad you asked. Checkers was my case. Checkers was about compensability of an accident. I think Your Honor asked the question that I thought was the burning question that needed to be asked, and Cespedes, I think, sets forth the rule most accurately, right? And that is that once compensability of an injury is established, the carrier can no longer contest that the accident is the major contributing cause of the injury. Major contributing cause is still in play. The claimant has to still show that that compensable injury is the major contributing cause of whatever treatment that is being requested as opposed to something else, right? So the carrier's accepted X, Y, and Z as compensable. Claimant's burden remains to show that the X, Y, and Z injuries that were accepted as compensable are more than 50% responsible for whatever treatment is going to be recommended by the doctor. If it's something else that's not X, Y, Z that the doctor is recommending treatment for, then the claimant can't meet his burden of major contributing cause. The claimant also has to obviously prove medical necessity, right? So these things still remain the claimant's burden, but the foundation for waiver of compensability, and the carrier complains about this much in their briefs about, we're not deciding cases on their merits. Well, that's because this is exactly what the legislature has told us, right? This waiver of compensability doesn't appear once in the statute, it appears twice. We see it in 440.20 subparagraph 4. We see it again in section 440.192 subparagraph 8, right, which basically says the same exact thing in a different way. It says that a carrier that does not deny compensability in accordance with 440.24 is deemed to have accepted the employee's injuries, right? Injuries is important, not accident. Injuries, because this fortifies our conclusion in our brief that the 120-day rule does not just apply to accidents, as the carrier is urging you to accept under Josephat. That's a fiction. Josephat was about a claimant's failure to prove medical necessity and major contributing cause. Josephat was not a statement of this court where it sub silentio overruled a dozen prior cases which have held that the 120-day rule applies to injuries and not just accidents. So my point simply being that the legislature has spoken loudly, clearly, and on more than one occasion in two different provisions, telling us that the 120-day rule does not just apply to accidents, it applies to injuries and in 440.20 to entitlement to benefits. And that's why you got it right in Cespedes, you got it right in Tico, you got it right in Sierra, you got it right in Sullivan, you got it right in McIntosh, you got it right in all of these cases. And the Josephat case does not represent some cataclysmic shift away from all these, saying that the 120-day rule only applies to accidents, as they've argued in their briefs. That's just not true. You cannot, a fair reading of Joseph can't lead you to arrive at that conclusion.
So let's assume that there's a clear record and, you have this degenerative condition that's revealed in diagnostic testing, that the treating physician orders treatment for that, and there's no denial, there's no challenge to that, and so that's determined to be compensable, right? But even then, the employer carrier is always going to have an MCC defense, there's a burden for the claimant to show it's still the MCC, so that the EC can come in and show, like, this is an 80-year-old claimant, they have a history of degenerative disease, and the accident and the injury does not require treatment.
The carrier always has outs, right? And
Right.
we argued this in Churchill, we argued it today.
So even if they fumble, right? Even
Right.
if they fumble, and I'm not suggesting that happened here, but on a clear record where it's a clear, yes, the authorized physician is treating from something that for a condition that does not appear to have been occupationally caused.
Yeah. Carrier still has its defense that the work injury that it accepted as compensable is not the major contributing cause of the need for treatment. Carrier still has its defense as to medical necessity, and the carrier still can establish facts material to the relevant to the issue of compensability that could not have been discovered through a reasonable investigation within the 120-day period. They've got a whole set of arrows in their quiver that they can draw from to get out from what they perceive to be an overly onerous application of the 120-day rule. What the legislature intended to do is encourage, this is all consistent, right, with the legislative purpose that we have a system that is quick and efficient. And what the legislator is wanting carriers to do is to make quick determinations within 120 days about what's related and what's not related, right? And if you don't think it's related, there's no fourth category of uncertainty. It's either you admit it, you deny it, or you investigate it. And the carriers tried to create this fourth category of uncertainty, which doesn't exist. They admit that they were not uncertain. In other words, they were certain that they wanted to deny it. Well, if you're certain you want to deny it, then what you do, and this goes to one of the last questions you had answered, it's pretty simple. We talk about it in our brief. We use this cheesy Linda Ronstadt analogy. It's so easy, right? File a notice of denial. When the doctor gives you a report and says, diagnosis herniated disc and cervical spondylosis, file a notice of denial and say, you know what, cervical spondylosis is not related. We'll treat the herniated disc as related. And now the doctor knows, the carrier knows, and the claimant knows what is compensable and what is not compensable, right? This all is congruent with how this system is allowed to operate in a quick and efficient manner, make these quick compensability determinations. The legislature also wants the carrier to make quick determinations on medical necessity, right? You have 3-day waiver and 10-day waiver penalties that apply for not responding to a request within a certain amount of time based on waiver of medical necessity. So it's all congruent within an overall cogent legislative scheme. So, Your Honors, we would ask the court to either affirm the decision of the judge of compensation claims, or in the event that you should determine that jurisdiction doesn't exist as a result of the carrier's failure to secure an appropriate certification under the rule, that the appeal be dismissed. Thank you.
Thank you, counsel.
All right, Judge Lewis, you asked, does it have to be a dismissal or can it be a remand? Here's why it can be a remand, in my opinion. This was not a case, we could not have used the 9.180 certification because there was nothing else to present. There was no other evidence that needed to be fleshed out. There was no substantial time and expense. We were ready to adjudicate everything right there. So it just needs to be remanded, in my opinion. And Mr. Weiner says, well, they still have their major contributing cause defense, but the judge refused to consider it. We were arguing, Judge, you have to rule on causation. And he said, no, I don't. I don't have to rule on causation because you lost on waiver. Therefore, causation doesn't matter. And he certainly did not accept Dr. Smith's opinion. He summarized Dr. Cronin's opinion. He summarized Dr. Weber's opinion. He summarized Dr. Smith's opinion. And then he said, I don't have to reconcile it because you lose on waiver. And look, the fundamental point that I'm making in this case is that MRI findings are not injuries. He says you have to determine what the injury is. We know what the injury is. He suffered a neck injury. He suffered a shoulder injury. That's what the injury is. It's not spondylosis.
And I just want to go back to your remand. What are we remanding for the JCC to do? I mean, shouldn't this just be a dismissal and, leave the parties where they are and you can proceed from there?
Well, Your Honor, I guess if you're going to conclude you have absolutely no jurisdiction to do anything, then I guess you have to dismiss it.
Yeah.
Well, Your Honors, thank you very much. I appreciate your
Counsel,
time.
Before you start, I think you've already addressed this question, but Appley argues that Appley still has the burden of showing that the work accident remains the major contributing cause of disability or need for treatment, and that treatment is reasonable and medically necessary. Do you agree with that statement?
I agree with that, but I guess my counter to that would be, okay, so the judge has made this ruling that now I apparently can't appeal, and he's found these MRI findings, all the unrelated underlying disease, he's found them compensable. So now we go back and we say, Judge, it's not related to the work accident. And he goes, well, it might not be related to the work accident, but I already ruled it's related to the underlying MRI findings, so you lose either way.
Well, then you take an appeal from that final order.
Oh, and we
Right?
will.
Right.
We'll see you again in 8 months. Thank you, Your Honors.
And thank you, Counselor, for your respectful oral arguments this morning. We are adjourned.
All rise.